Live yet? All right, welcome to the Great American Mail live stream of the Supreme Court arguments that are scheduled to start today in the case of taking Trump off of the Colorado ballot. The Great American Mail, the American lawyer that breaks down the news of the day through the lens of the law, the Constitution, and history. This should be, frankly, an open and shut case. It looks like the Supreme Court is not ready to go. So let's back up and tell you what this is all about. Why are they trying to, well, we know why they're trying to take Trump off the ballot. It's essentially to interfere in the election. But what's the basis of it? The basis of it here, I've got Section 3 of the 14th Amendment from the Cornell Law School website, and it reads, you can read it there for yourself if you want, but I'm going to read it for you. And we're going to then explain why this should be a 9-0 decision. It should be very easy for the Supreme Court to overrule the Colorado Supreme Court, which found that Trump isn't eligible based on this amendment. And there's a lot of things you need to know as a back. But let's read the amendment to start there. I'm going to keep an eye on the Supreme Court, make sure. Okay, all right. Right, let's read the thing. No person shall be a senator or representative in Congress or elector of the president or vice president or hold any office, civil or military, under the United States or in any state who, having previously given an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer in any state to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a 2/3 vote of each house, remove such disability. Folks, that's it in a nutshell. That's what we're arguing about. The Democrats are claiming that the January 6th was an insurrection, and therefore, under their reading of this clause, which is bogus as it comes to the president specifically, but their reading is because it's an insurrection, anyone who ever served as a prior person in any office, if you read this broadly, and I do think it does apply that broadly, any person who ever held any office that took an oath to support the Constitution, if January 6th is an insurrection and you engaged in it, then you're taken off the ballot. Now, the first big problem you're going to see here, and I'm guessing the court is, when they get to it, or hopefully, let's refresh this, make sure we don't miss any oral argument here. But if they, are going to get into this today and examine this, let's see, wait a minute, we may have it here. Well, it doesn't say. All right. Well, anyway, the first big problem you're going to have, let's try to refresh this one, make sure we're not missing any audio. Here we go. That may be it.
A healthy democracy doesn't just look like this. It looks like this, where Americans can see democracy at work.
So anyway, so here's the first big problem. If you look at that, notice it says no person shall be a senator or representative in Congress, elector of the vice president or vice president. Okay, that is the electors that go to the Electoral College, right? So they've already said senators, congressmen, and now they say you can't be an elector. Then they say or hold any office, civil or military in the United States, right? So that's everyone else. Notice the president is not mentioned here. And that should come up today. It's interesting. To me, it's the glaring reason that this thing does not apply to the presidency. And I'm going to pull up the argument or the article, which if you look down in the stream, if you're listening on Twitter, I don't think it's there. If you go to our YouTube channel, it's there. I'll tweet it out later today. But there are a lot of problems. Here's an article we wrote at the Great American Mail Substack page, www.greatamericanmail.substack.com. The 14th Amendment does not apply to the presidency. And basically, again, the big arguments why it does not, if you read, and there it is right here, here's the language that I just read for you already. If the real reason it doesn't apply to the president, right? Well, back up. First off, January 6th wasn't an insurrection, right? I mean, obviously, anybody reading this clause in any sincerity really knows that what they mean. I clicked the play button and you didn't start.
One of the best times business-wise in my life, and I was impressed by what Donald Trump was doing. And I'm just...
They may have started.
And watching this, we've in the past seen other candidates doubt what was happening with the election, challenge it, no issues. But this time, he's challenging something that looks so obvious because of all the lies and deception that was going on with the democratic circumstances of impeachment. They had no grounds. They had no actual evidence.
That's Mark in Green Valley. This is Andy in Lewiston, California. Good morning. You're next.
Yes, good morning.
No, that must be the C-SPAN. Okay, that's not helping. All right, so sorry, folks. The audio is a little bit off. I haven't live streamed in a while. It looks like the court is still not live, so we'll just keep waiting for that. So let's come back to what's going on here. Sorry about that. Why it doesn't apply to the presidency. So the first reason it does not apply to the presidency is if you read the clause itself. First off, it's not an insurrection. Second of all, even if it is an insurrection, right, it does not apply to the presidency. Third, even if it does apply to the presidency, which it clearly doesn't, right? Trump did not aid anything. We've got another article, and it's up at I'll tweet it out later today as well, but it's at the Substack page talking about what January 6th was about. January 6th was about a very specific challenge that Trump was trying to make to Biden's certification, and I'll just try to keep an eye on C-SPAN, so maybe they'll go to the court as well. He was trying to make a very specific
healthy democracy
challenge to Biden's certification. The last person that wanted any violence on that day was Donald Trump, and the reason he didn't want any violence on that day was because you had 7 senators and 139 congressmen, I believe, ready to stand up and object to the certification of 7 states. And as soon as they stood up to make the election in the Electoral College, the states are called in alphabetical order. As soon as they got to Arizona, which was the first alphabetical order state that they were going to challenge the certification to, that's when the Congress was breached. That's when Nancy Pelosi got up and said, we cannot continue with the Electoral College certification. And I don't know why they're so late here. Courts are often late, but they're usually not this late at this level. Normally, appellate courts are a lot more timely. Anyway, so as soon as the violence started, that challenge stopped. It ceased in its tracks. As we all know what happened then, Pelosi and the others went out. Order was reestablished in a few hours. And at that point, the entire plan that they had set forth to challenge Biden's certification, and they may talk about it today, we'll see. But if they do, that all ended as soon as the Capitol was breached. So the last person that wanted that to happen was Trump. And just so you know, all of this stuff, and I'll tweet out the article. And if you're watching on YouTube, by the way, please subscribe. But I'll put it in the YouTube feed later. It's not in there yet, but I'll put it in there. Another article that'll walk you through what that challenge was. And just so you know, the AP was reporting that Trump was going to do that as early as November of 2020. Everyone knew this was coming. You can't just show up with alternate electors. You just can't show up with an objection. You have to send stuff to the Congress through the United States mail beforehand. Everyone knew it was what was going to go on. I don't know why they're not starting on time. Let's see here. Still nothing. Let's check out Turley's feed. I think Turley said he was going to do it as well. See if he's got it coming up. And then I'm going to go through a couple of more reasons why why no one really should be subject to this, but it doesn't come up as much. Oh, come on. Can't type. If they would just start on time, we wouldn't have this problem. State courts, a lot of times, lower courts will start late, but usually appellate courts are Johnny on the spot with these things. Let's see what Turley's got going on. He says he's going to start, but looks like he hasn't started either. All right. So it looks like the court has not started yet. So, all right. So let's break down the arguments why the language. So first off, the language itself doesn't apply to the president. Here's the other problem that they have. It's not an insurrection, right? And so real quickly about this officer of the United States, this should come up today. What's going to happen is people like Lawrence Tribe and Judge Ludwig, these people who are just frauds and try to say, yeah, they mention senators. Yeah, they mention congressmen. Yeah, they mention, electors, right? But then where these other people are, or hold any office, civil or military, under the United States. That's where president is. President is hold any other office, right? That's all that is. Well, that's not true. The president is not an officer of the United States. Never has been. Has never been considered that. In fact, if you look at the Constitution, it says the president shall appoint the officers of the United States. The big difference here, the president is essentially the executive branch. in and of himself. He is the executive branch. He is not an officer of the United States. He is the president, completely aside from all of this. And there's a good reason to know why they probably wanted to exclude him. But there's a couple other things, and I just don't want to miss the start of this, so I'm going to keep clicking on it and see if we can get it to go. I hope we're not missing this. Let's try C-SPAN again. And let's try and see if Turley's up. He should be. I don't see his feed starting either. Nope. I don't know why they haven't started. I thought they were going to start at 10.
We'll hear argument this morning.
Here we go.
23-719, Trump versus Anderson. Mr. Mitchell.
All right.
Mr. Chief Justice, and may it please the court. The Colorado Supreme Court held that President Donald J. Trump is constitutionally disqualified from serving as president under Section 3 of the 14th Amendment. The Colorado Supreme Court's decision is wrong and should be reversed for numerous independent reasons. The first reason is that President Trump is not covered by Section 3.
Okay, that's the best argument.
The president is not an officer of the United States, as that term is used throughout the Constitution. Officer of the United States refers only to appointed officials, and it does not encompass elected individuals, such as the president or members of Congress.
Absolutely correct.
This is clear from the Commissions Clause, the Impeachment Clause, and the Appointments Clause, each of which uses officers of the United States to refer only to appointed and not elected officials. The second reason is that Section 3 cannot be used to exclude a presidential candidate from the ballot, even if that candidate is disqualified from serving as president under Section 3.
This argument is
Congress
weaker.
can lift
I
that
don't like
disability after the candidate is elected, but before he takes office.
It's too legally
cannot
technical.
Exclude any candidate for federal office from the ballot on account of Section 3, and any state that does so is violating the holding of term limits by altering the
It's too technical.
Constitution's
It's correct, but it's too
qualifications for
technical.
federal
People,
office.
this is a weak
The
argument.
Colorado Supreme Court's decision is no different from a state residency law that requires members of Congress to inhabit the state prior to Election Day, when the Constitution requires only that members of Congress inhabit the state that they represent when elected. In both situations, a state is accelerating the deadline to meet a constitutionally
Spending
imposed
too much time on this too.
qualification.
This is a bad
Is
idea.
thereby violating the holding of term limits. And in this situation, a ruling from this court that affirms the decision below would not only violate term limits, but take away the votes of potentially tens of millions of Americans.
And that's
I
powerful.
welcome the court's questions.
Mr. Mitchell, would
Wow.
you didn't spend much time on your argument with respect to whether or not Section 3 is self-executing.
Exactly.
So would you address that?
And self-executing means
And
Congress has to
doing that,
pass a law, or is it self-executing? Clearly, it
Your
needed.
argument is that it's not self-executing, but
Let's
then
show you here
in
what
that
Thomas is
case,
talking
what would
about.
the role of the state be?
Right
Or
here,
is
the
it
Congress shall have the
entirely
power to
up
enforce
Congress
by appropriate
to
legislation
implement,
the provisions of this article.
the
That's telling you it's not
disqualification,
self-executing. Right
in
there, that's
Section
Section 5.
3.
They never
It is
passed it.
entirely up to Congress, Justice Thomas, and our argument goes beyond actually saying that Section 3 is non-self-executing. We need to say something more than that, because a non-self-executing treaty or a non-self-executing constitutional provision normally can still be enforced by a state if it chooses to enact legislation. The holding of Griffin's case goes beyond even that.
Yeah,
by
I
saying
don't
that
like
a
where this
state
is
is
going.
not
I would just.
to implement or enforce.
Thomas just gave you a
Section 3 of the
softball, and this
14th
guy's
Amendment,
fumbling it.
unless and until Congress enacts implementing legislation allowing it to do so. So under Griffin's case, which we believe is correctly decided, the Anderson litigants disagree with us on that point. But if this court were to adhere to the holding of Griffin's case, there would not be any role for the states in enforcing Section 3 unless Congress were to enact a statute that gives them that authority.
Okay, all right. He came back around to it. Wasn't as clear as it could be.
What if somebody came into a state Secretary of State's office and said, I took the oath specified in Section 3, I participated in an insurrection, and I want to be on the ballot? Does the Secretary of State have the authority in that situation to say, no, you're disqualified?
No, the Secretary
No.
of State could not do that consistent
Correct.
with term limits, because even if the candidate is an admitted insurrectionist,
Right.
Section 3 still allows the candidate to run for office
That is
and
correct.
even win election to office,
Right.
and then see whether Congress lifts that disability after the election. This happened frequently in the wake of the 14th Amendment, where Confederate insurrectionists were elected to Congress, and sometimes they obtained a waiver, sometimes they did not, and each House would determine for itself whether to seat that elected insurrectionist, because each House is the sole judge of the qualifications of its members. So if a state banned even an admitted insurrectionist from the ballot, it would be adding to and altering the Constitution's qualifications for office, because under Section 3, the candidate need only qualify during the time the candidate holds the office to which he's been elected. And under Your Honor's hypothetical,
I still don't like this line of argument. I mean, it's technically right, but it's just...
the candidate obtain a waiver from Congress earlier than the candidate needs to obtain that waiver.
Well, even though it's pretty unlikely, or at least would be difficult for an individual who says, you know, I am an insurrectionist and I had taken the oath, that would require 2/3 of votes in Congress, right?
Correct.
It would under the amendment, but and I'm not sure why he hasn't mentioned Congress did it twice shortly after the amendment was passed.
Because in doing so, they're adding a new qualification to the ability to run for Congress. And the proper analogy, Mr. Chief Justice, is to state residency laws, because the Constitution says that a member of Congress must inhabit the state that he represents when elected. And the lower courts have all held, in reliance on term limits, that a state election official cannot move that deadline any earlier by requiring the candidate for Congress to inhabit the state.
So even if somebody comes in and says, I'm a resident of the Secretary of State's office in Illinois, and says, I'm a resident of Indiana, I have been all my life, I want to run for office in Illinois, the Secretary of State can't say, no, you can't?
Well, the question would be, is that person going to inhabit the state when the election
I think what they're trying to do here on the Trump team, I think they're trying to say, hey, you don't need to get into this insurrection and this 14th Amendment stuff. Here's another technical reason why you don't have the power to take people off ballots, which they're right about that. But I think it's more important to focus on January 6th, because this is bigger than just this ballot case. But I think this is the Trump team saying, hey, here's two reasons. One, it's not, 14th Amendment doesn't apply, no insurrection. Number two, here's this technical thing where you can't have states taking people off ballots without Congress passing a specific law. That's what they're saying. It's a good technical legal argument, but I think the stronger thing is to attack the 14th Amendment.
Can I stop you a moment and back up a minute? You admitted that the concept of self-executing does generally permit states to provide a cause of action for breaches of a constitutional
One of the leftists, this is Sotomayor, I believe.
In fact, they do it frequently for takings clauses. There's no debate that Colorado has provided that cause of action. You want to go a step further and say that this, like the treaty clause, requires implementing legislation to permit the state to disqualify an insurrectionist.
That's correct. So
under Section 3.
That's right.
Yeah,
so
that's correct.
History proves a lot to me and to my colleagues generally. But there's a whole lot of examples of states relying on Section 3 to disqualify insurrectionists for state offices. And you're basically telling us that you want us to go 2 steps further. You want to, maybe 3. You want us to say that self-execution doesn't mean what it generally means.
That's not true.
You want us now to say it means that Congress must permit states or require states.
It says it right here in the Act.
Stop
Here it is, Section 5.
from taking state office. And
Congress shall have the power to enforce by appropriate legislation. They haven't done that.
In a way that's very rare, isn't it?
Well, that's the only thing I would disagree.
It's rare under the 14th Amendment.
Oh, of course it's rare. This is a one-off situation. And, Your Honor, the only thing
Well, it is one-off. I don't disagree with you. But it's not with respect to how we've defined self-executing.
We're not asking this court to redefine the concept of non-self-execution. We were careful in our brief not to rely on that phrase. And Griffin's
right,
case
you are, because it's not.
That's right. And Griffin's
so
case.
Now the question is a very different one in my mind. I understand what you're relying on, Griffin. Let's just be very clear.
Right.
Griffin was not a presidential Supreme Court decision.
That's correct.
All right? It was a circuit court decision by a justice who, when he becomes a justice, writes in the Davies case.
So this is Justice Chase. He said it wasn't self-executing in one, and then later when he came on the court, he said it was.
Any office, particularly
a technical legal argument here. What they're saying is,
and this is his words, Section 3 as executing itself, needing no legislation on the part of Congress to give it effect.
So what she's saying is that he didn't think it was self-executing, or he thought it was self-executing, and if it's self-executing, then Colorado can do what it did. So it looks like we're not going to get Sotomayor. This is nonsense.
But the key point with Griffin's case and why it's an important precedent, despite everything Your Honor said, it is not a precedent of this court. But Griffin's case provided the backdrop against which Congress legislated the Enforcement Act of 1870 when it first provided an enforcement mechanism for Section 3.
And it did away with it later.
It did away with it later. But
that has nothing to say with respect to what Section 3 means. Can we get to the issue, which is, I think, one that I go back to that I started with, and very briefly, what sense does it say that states can't enforce Section 3 against their own officials?
Oh, my God. Well,
I think logically those are two separate issues.
That's interesting. It'd be one thing if you're doing it against your own state officials. They're trying to do it against a federal official.
Holders, or can they enforce it against federal officials, or can they enforce it against the president? Those are all three different questions.
She's correct. They are three different arguments, and all should be answered in the negative. They cannot.
Turns on whether this court agrees with the holding of Griffin's case. If Griffin's case is the proper enunciation of the law, then a state cannot do any of the things Your Honor suggested unless Congress gives it authority to do so.
So a non-presidential decision that relies on policy doesn't look at the language, doesn't look at the history, doesn't analyze anything than the disruption that such a suit would bring, you want us to credit as presidential?
Because Congress relied on Griffin's case when it enacted the Enforcement Act of 1870 and established...
So, Mr. Mitchell, if I may interrupt, but just to clarify, I mean, this sounds like your reply brief, where it sounds like you're not making a constitutional argument, you're really making a statutory preemption argument. And is that what you're doing here? You're not saying that the Constitution gives you this rule. It's the kind of combination of Griffin's case plus the way Congress acted after Griffin's case that gives you the rule?
That's exactly right, Justice Kagan, because we have implementing legislation. Congress took up the invitation provided by Griffin's case and established writs of quo warranto in the 1870 Enforcement Act, later repealed them. The only enforcement legislation that's currently on the books is the Insurrection Criminal Statute, Section 2383. And when Congress made all of these decisions, the initial enactment of the Enforcement Act in 1870, the repeal of the quo warranto provisions in 1948, all of those were made with Griffin's case as the backdrop.
Please.
Well, the understanding was that these congressionally established remedies would be exclusive of state court remedies. So there's not an express statement of preemption in these statutes, but there didn't need to be because Griffin's case provided the backdrop.
And if I could just understand the argument a little bit better, suppose that we took all of that away. You know, suppose there were no Griffin's case and there were no subsequent congressional enactment. What do you then think the rule would be?
Very easy. You need a statute.
As a matter of first principles without Griffin's case, it's a much harder argument for us to make because normally, I mean, every other provision of the 14th Amendment has been treated as self-executing. What we would argue, and that's hypothetical that Your Honor has suggested, is that there are practical considerations unique to Section 3 that counsel in favor of a rule similar to what Chief Justice Chase spelled out in Griffin's case. And it goes to, I think, the policy concerns he talks about, where this was a case, Griffin's case involved a convicted criminal who was seeking a writ of habeas corpus on the ground that the judge who tried his case was an insurrectionist disqualified under Section 3. And Chief Justice Chase realizes that if he enforces Section 3 in this situation, it would nullify every official act taken not only by this particular judge, but by anyone who is an insurrectionist or arguably an insurrectionist under Section 3.
Well,
and that was
why do you need those consequential concerns?
This is Justice Jackson.
It seems to me that what Justice Kagan is getting at is why don't you have an argument that the Constitution of its own force, that Section 3 of its own force preempts the state's ability, not necessarily, I think, not to enforce Section 3 against its own officers, but against federal officers.
No, that's
in a Tarbles
Barrett.
case,
It's Barrett, sorry.
So there could also be an argument that's more limited. You're suggesting there may be a barrier under the Constitution to a state legislating an enforcement mechanism for Section 3 specific to federal officers. We could rely on precedents such as McClung that says that state courts lack the authority to issue mandamus relief against federal officials.
Well,
and
why
extend
aren't
that
you
principle
making
here.
those arguments?
Because that doesn't get us, that Griffin's
That
case
only
goes,
gets you out of state court, it doesn't get you out of federal
right.
court.
And also the holding of Griffin's case went well beyond that, because Chief Justice Chase said in this opinion, which again provided the backdrop for the congressional enforcement legislation, that states had no role in enforcing Section 3 unless Congress was to give them that authority through a statute that they passed pursuant to their Section
But your
5 powers.
arguments,
No, please, go ahead.
I was just going to add one last thing. I think your argument's a little broader than that, because I think if we accept your position that disqualifying someone from the ballot is adding a qualification, really your position is that Congress can't enact a statute that would allow Colorado to do what it's done either, because then Congress would be adding a qualification, which it can't do either.
That's a
I
good
don't agree
point.
with that, Justice Barrett.
That's a
Congress
good
is
point.
not bound by the holding of term limits. Term limits only prohibits the states from adding additional qualifications or altering the Constitution's qualifications for federal office. It does not purport to restrain Congress. So if Congress were to enact implementing legislation that authorized the states to exclude insurrectionists from the ballot, we believe that would be valid enforcement legislation under Section 3, with an important caveat. There has to be congruence and proportionality under this court's precedent. So
why would that be permissible? Because Section 3 refers to the holding of office, not running for office. And so if a state or Congress were to go further and say that you can't run for the office, you can't compete in a primary, wouldn't that be adding an additional qualification for serving for president? You must have been free from this disqualification at an earlier point in time.
Surprised we're spending so much time on these technicalities when it doesn't apply at all.
Depends on how you interpret the word enforce in Section 5. And some members of this court, such as Justice Scalia, thought that enforce means you can do nothing more than enact legislation that mirrors the 14th Amendment's self-executing requirements, and you can't go an inch beyond that. That's not the current jurisprudence of this court.
No, well, all right, you have to decide whether it's congruent and proportional, and we would get into the question of whether that would be congruent and proportional. Well, let me shift gear a little bit.
Good,
I take
please.
you to argue, and I think this is right, that the term self-executing is a misnomer as applied here.
Yes,
very often, when we use the term, what we're referring to is the proposition that a particular provision of the Constitution or a statute in and of itself creates a private right of action. That's not what the issue is here.
No, that's not the issue here, and sometimes the phrase self-executing is used that way. The only thing I would add is sometimes it's used in a different sense. With self-executing treaties or non-self-executing treaties, the issue is whether that treaty has any force as domestic law whatsoever.
Right. Well, I don't see what is gained by using this term, which is used in different contexts, rather than directly addressing what's involved here, which is the question of who can enforce Section 3 with respect to a presidential candidate. The consequences of what the Colorado Supreme Court did, some people claim, would be quite severe. Would it not permit, would it not lead to the possibility that other states would say, using their choice of law rules and their rules on collateral estoppel, that there's non-mutual collateral estoppel against former President Trump? And so the decision of the Colorado Supreme Court could effectively decide this question for many other states, perhaps all other states. Could it not lead to that consequence?
I don't think so, because Colorado law does not recognize non-mutual collateral estoppel, and I believe the preclusive effect of the decision would be determined by Colorado law rather than the law of another state. But I think your question, Justice Alito, gives rise to an even greater concern, because if this decision does not have preclusive effect in other lawsuits, it opens the possibility that a different factual record could be developed in some of the litigation that occurs in other states, and different factual findings could be entered by state trial court judges.
Truly was not expecting this to get this into the weeds.
President Trump did not have any intent to
when
engage in
it really just doesn't apply at all.
Make some other finding that differs from what this trial court judge found.
Yeah, exactly. So in this decision, the trial court in Colorado thought that it was proper to admit the January 6th report And it also admitted the testimony of an expert who testified about the meaning of certain words and phrases to people who communicate with and among extremists, right? Another state court could reach an opposite conclusion on both of those questions.
Certainly. Other states could conclude that the January 6th report is an admissible hearsay. They might also conclude that statements
because it is
within the
ranked
January
admissible
6th
hearsay.
report were hearsay, even if the report itself is not. And they could certainly reach a different conclusion with respect to the expert testimony of Professor Simi. Perhaps in another state we would have time to produce our own sociology expert who would contradict Professor Simi.
Should these considerations be dismissed as simply consequentialist arguments, or do they support a structural argument that supports the position that you're taking here?
I think they all mutually reinforce each other. We have an argument, we believe, that is sufficient to dispose of this case just based on the meaning of officer of the United States, as well as the argument we're making based on term limits. But all of the consequentialist considerations that Your Honor has suggested are additional reasons to reverse the Colorado Supreme Court, although we don't think it's necessary to get into consequences because the law is clearly on our side.
You keep saying term limits. There are other presidential qualifications in the Constitution: age,
yes,
citizenship. There's a separate amendment, the 22nd Amendment, that doesn't permit anyone to run for a second term. We have a history of states disqualifying, not all, but some, of disqualifying candidates who won't be of age if elected. We have a history of at least one state disqualifying someone who wasn't a U.S. citizen.
Right.
Are your arguments limited to Section 3?
Not quite. The question, Justice Sotomayor, is whether the state is violating term limits by adding to or altering the extant qualifications for the presidency in the Constitution. Now,
so you want us to say, I'm wondering why the term limits qualification is important to you.
Because
are you setting up so that if some president runs for a third term, that a state can't disqualify him from the ballot?
Of course a state can disqualify him from the ballot, because that is a qualification that is categorical. It's not defeasible by Congress. So a state is enforcing the Constitution when it says you can't appear on our ballot if you've already served 2 terms as president. The same
if they're underage when elected, and the same if they're not a U.S. citizen.
The same if they're not, well, the same if they're not a U.S. citizen, for sure. The age is a little more nuanced, because you can imagine a scenario where the person is 34 years old at the time of the election, but he turns 35 before inauguration.
Well, then that would come up. That would probably come up to us at some point. The state would make a decision and say he's ineligible, and we would have to decide that question then. But my point is, so what? Adding qualifications to what term limit? Is your argument based on?
I still can't believe we're so in the weeds here on something that just clearly does not apply.
If a state like Colorado says you can't appear on our presidential ballot unless you are 35 years old on the day of the election, that would be a violation of term limits, because there could be a 34-year-old on the day of the election who turns 35 before inauguration.
I mean, it doesn't apply. We're sitting here talking about other things.
What the Supreme Court has done is similar, because under Section 3, President Trump needs to qualify during the time that he would hold office. And the Colorado Supreme Court is saying to President Trump, you have to show that you would qualify under Section 3 now, at the time of the election, or at the time that we, the state Supreme Court.
Now I understand.
Now, just a point of clarification so we're all on the same page. When you say term limits, you mean our decision in the term limits case.
Yes,
not
I'm sorry.
The constitutional provision governing term limits.
Yes, U.S. term limits against Thornton. Maybe I should call it Thornton instead of term limits.
That would be
sorry.
easier
for you. Does it have something to do with the fact that the particular circumstances you're talking about can change? Is that what you mean? I'm trying to understand the distinction between the provision in the Constitution that relates to disqualification on the basis of insurrection behavior and these other provisions that Justice Sotomayor points out. They all seem to me to be extant constitutional requirements. So
she's saying they're the same. She's saying, hey, if some rogue person says you engage in an insurrection, it's no different than them saying you're not old enough.
Whether or not you are an
it's ranked nonsense.
Is or is not categorical?
It is not categorical because Congress can lift the disability by a 2/3 vote.
And they did twice, which they have not mentioned.
Why does that change the initial determination of whether or not you fall into the category? I don't understand the fact that you can be excused from having been in the category. Why does that not make it a categorical determination?
Because we don't know whether President Trump will be excused before he's sworn in, if he wins the election, on January 20th, 2025. And a court that is saying that President Trump has to show now, today, that he would qualify under Section 3 is accelerating the deadline.
He's right about this, but it's too in the weeds, right? And you got to get out of this. It's
That's
just
by
like
virtue of the hold, right? Hold office. This is
correct. Section 3 bans him only from holding office. It
all right,
does
can
not.
I ask you? I'm just.
I mean, it's a good technical argument, but
Can I ask you to address your first argument, which is the officer point?
Okay, good.
Oh, sorry.
Yeah, why don't we? Could we? Is that okay if we do this and then we go to
Sure,
that?
sure.
You know,
Go ahead.
will there be an opportunity to do officer stuff, or should we?
Absolutely.
I just want to understand. So, on this theory, what is the sum total of ways that that Section 3 can be enforced? That somebody out there can say, yes, there's been a former president who engaged or led or participated in an insurrection, and so should be disqualified from office.
Enact legislation pursuant to Section 5. Right there. Congress should have power to enforce it. That's how you do it.
So the answer to that question is going to depend on what Your Honor thinks of Griffin's case. So if this court were to affirm the rationale of Griffin's case, then the only way Section 3 could be enforced is through congressional legislation.
Correct.
That creates a remedy. So Congress could reinstate the quo warranto provisions that they initially had in the 1870s.
Is that your position?
Yes, because we believe Griffin's case is correctly decided and should be followed.
And how does that fit with a lot of the answers to the questions that we've been given? You said, well, Congress has to have the ability by a 2/3 vote to lift the disqualification.
Right.
But
because
so
that's
too,
in the amendment.
I would think that provision would be in some tension with what you just said.
There is
because if Congress has the ability to lift the vote by a 2/3 majority, then surely it can't be right that one house of Congress can do the exact same thing by a simple majority.
Yeah, there certainly is some tension, Justice Kagan, and some commentators have pointed this out. Professor Bode and Professor Paulson criticized Griffin's
case
very
sharply. Then I must be
sharply.
right.
Well, we don't think this problem is fatal, because to us the 2/3 provision that allows Congress to lift a disability is something akin to a pardon power, where Congress, through enforcement.
This is where they're talking about Section 3, the last line.
Insurrectionist issue is to be
but Congress may have.
By some
Congress may, by a vote of 2/3 of each house, remove such disability. They've already done it. I'm surprised he's not making this argument. Because it's a powerful argument.
The situation of Congress, it would be whatever Congress enacts. So when it was the writs of quo warranto, each federal prosecutor had the authority to bring a quo warranto writ against an incumbent official and seek his ouster from office.
Also, frankly, surprised he hasn't brought up the fact that, hey, everybody knew the insurrection was the Civil War. Now we're talking 150 years later. There's no insurrection. But he hasn't mentioned that either.
There's tension. If you analogize the lifting by Congress of the disqualification by a 2/3 vote to a pardon, then surely one would not argue that the fact that the president or governor can pardon someone from a criminal conviction or a criminal offense means that the person couldn't be prosecuted in the first place for the criminal offense.
That's right.
Right?
Good point.
So I don't see what the tension is. They're two separate things. Did the person engage in this activity, which is prohibited?
Correct.
And second, even if the person did engage in the activity, are there reasons why the disqualification or should be lifted or the pardon should be granted?
That's right. I mean, if the court accepts the holding of Griffin's case, that's exactly the regime that we would have.
Yeah, I don't see there's tension, but also there's a limit on what one can infer from the mere fact that Congress can lift the disqualification.
Unbelievable this is going this far.
You can't infer from that it is impermissible to have a prior determination that the person did engage in the insurrection. You can't make that inference.
Okay.
It's not
Well,
logical.
but I think
what you're doing?
What's in tension is that you would have the exact same actor and say, look, that actor can lift the disqualification by a 2/3 vote, but you're saying only that actor can put the disqualification into effect in the first place, and it can do that by far less than 2/3. It can do that just by a simple majority.
They're going way too far off on this. And what they're basically saying is, hey, they might lift the disability, so there's no reason to keep him from the ballot, right? Technically, it's a great legal argument, but and it's right, but I don't think you need to get there. I think ceding this ground is a bad idea.
+1 saying we don't feel like it.
But that's why we tried to characterize our Griffin's case argument the way we did, where we rely on preemption doctrines as well. So we have.
Don't you think Griffin's case is also relevant to trying to figure out what the original public meaning of Section 3 of the 14th Amendment is? It's by the Chief Justice of the United States a year after the 14th Amendment. That seems to me highly probative of what the meaning or understanding of that language, otherwise elusive language, is.
I do think it's probative, Justice Kavanaugh. We didn't rely too heavily on the point that you're making, partly because we have this other opinion from Justice Chase in the Jefferson Davis case. So that argument could potentially boomerang on us, which is why we didn't push it very hard in our briefing. But I think Your Honor is right. This is.
Why don't you finish your sentence?
It is relevant and probative for sure. But I think there is other evidence too that might perhaps undercut the usefulness of trying to characterize Griffin's case as completely emblematic of the original understanding.
Now, why don't we move on to the officer?
Yeah. So what you're saying there is that other people later said that it meant general insurrection, not just specific. That's the problem, which is nonsense, but it's out there.
Look at Section 3, I see two parts of the first sentence of Section 3. The first is a list of offices that a disqualified person is barred from holding.
Right.
And the second are specific circumstances that give rise to disqualification. So first, am I right about seeing that there are two different things happening in the first sentence of section? Okay.
For sure.
So here's the first.
Are you arguing both in this case or just one?
And then here's the second.
Both that the office of the presidency should not be considered one of the barred offices.
Correct.
And that a person who previously took the presidential oath is not subject to disqualification?
That's the argument I make here, and I'll tweet it out.
I don't see that in your brief. I see a lot of focus on the second, but not on the first.
There is definitely more focus on the second, and we acknowledge that we have a somewhat heavier lift on the first point.
Why? It seems to me that you have a list and president is not on it.
That's
right, exactly. Thank you, Justice Jackson. Thank you.
With respect to officer of the United States, that's used repeatedly in the Constitution, in the Commissions Clause, in the Appointments Clause, and also in the Impeachment Clause. And every time it appears, it's used in a way that clearly excludes the president.
I understand, but that's the second argument. So the first argument is
right.
We have a list of offices that a person is barred from
here you are.
Holding.
Right.
Yes.
Under your theory or under the language of, and we see it begins with senator,
Rep.
representative, elector of the president and vice president, and all other civil or military officers.
Correct.
Offices under the United States.
Offices under the United States.
Right. Here it is right here. Any office under the United States.
Does not
the president is not an office under the United States.
Specifically in that list. So I guess I'm trying to understand, are you giving up that argument, and if so, why?
No.
We're not giving it up at all. You're right. The president and the vice president are not specifically listed.
Correct.
But the Anderson litigants claim that they are encompassed within the meaning of the phrase office under the United States.
And do you agree that
they are not?
The framers would have put such a high and significant and important office, sort of smuggled it in through that?
Thank you, Justice Jackson. Yes.
That's why we're still making the argument that the presidency is excluded from the covered offices.
Correct.
At the beginning of Section 3.
I'm sorry. Your brief says you didn't take a position on that point.
I'm sorry.
And your brief said, I don't have the site, I apologize. You don't affirmatively argue that point, I think is what your brief said.
In the blue brief?
Yes.
Well, we certainly argued it in the reply brief, and I'll have to look at how we phrased it. But we did point out in our opening brief that there are potential issues if this court were to rule on office under, because that phrase appears in other parts of the Constitution, including the Emoluments Clause,
Correct.
The Impeachment Disqualification Clause.
Would we necessarily have to say, I mean, I thought the point was that Section 3 was unique, that there was something happening with Section 3 that could explain why certain offices were left off or whatnot.
Perhaps, but there are also implications from other parts of the Constitution which really help us on the officer of the United States argument, in that second part of Section 3, but somewhat cut against us when it comes to office under the United States. And the Anderson litigants point this out in footnote 9 in the red brief, where they say if this court were to say the presidency is an excluded office under the United States, that could imply, for example, the president is not covered by the emoluments.
Mr. Mitchell,
yes.
Stepping back on this, a lot hinges on the difference between, in your argument, between the term office and officer.
Yes.
And I guess I'm wondering,
this is Gorsuch.
What theory do you have from an original understanding or a textualist perspective why those two terms so closely related would carry such different weight?
Because it's clear from the constitutional text that there are officers that do not hold offices under the United States. For example, the Speaker of the House and the President pro tempore, they're described as officers in Article 1 who are chosen by the legislature. They also have to be officers if they're able to be covered by the Presidential Succession Act, because under the Constitution, only officers can serve when there's a vacancy in both the presidency and the vice presidency. So they're officers, but they're not offices under the United States.
Correct.
Because of the incompatibility clause, which says that if you're a member of Congress, you cannot simultaneously hold an office under the United States. So that provision of the Constitution clearly demonstrates
the left has made a lot of hay in confusing this. The president is not an officer under the United States.
Anything in the
He's not
original
directly elected by the people.
Drafting, history, discussion that you think illuminates why that distinction would carry such profound weight?
Not of which we're aware. So these are textual inferences that we're drawing from constitutional structure, intratextualist analysis. But we aren't relying necessarily on the thought processes of the people who drafted these provisions, because they're unknowable, but even if they were knowable, we're not sure they would be relevant in any event, because this language, especially in Section 3, was enacted as a compromise. There were certainly radical Republicans who wanted to go much further. If you look at some of the earlier drafts that were proposed, some people wanted to ban all insurrectionists from holding office, regardless of whether they previously swore an oath. Some people wanted to go further and ban them even from voting.
Thank you, Counsel. I just have one very technical question. The statute in 1870, if it were still in effect, would require you to modify your arguments slightly. It was repealed, as you say, in 1948. I tried to find it, but I couldn't. Do you know why it was repealed?
No, we don't know why. It looks like it was done as part of a reorganization of the U.S. Code. So it doesn't appear there was any policy motivation behind that decision. I think a lot of things got repealed during this 1948 decisions that were made.
Okay.
Wow, it's just shocking we don't know that.
Is there any history of states using Section 3 as a way to bar federal office holders?
Not that I'm aware of, Justice Alito, because of Griffin's case. I mean, Griffin's case has been the law. I shouldn't say that it's been the law, because it was just a circuit court decision. But that
contradicts what Sotomayor said earlier. She said lots of people. No, she may have been, to be fair, she might have been talking about state office versus federal.
Pin down your principal argument on Section 3. You argue that even though the president may or may not qualify, presidency may or may not qualify as an office under the United States, your principal argument is that the president is not an officer of the United States, correct?
Yeah, I would say it a little more forcefully than what Your Honor just described. We believe the presidency is excluded from office under the United States, but the argument we have that he's excluded the president as an officer of the United States is the stronger of the two textually and has fewer implications for other constitutions.
Bit of a gerrymandered rule, isn't it, designed to benefit only your client?
I certainly wouldn't call it gerrymander. That implies nefarious intent.
Well, you didn't make it up. I know some scholars have been discussing it, but just so we're clear, under that reading, only the petitioner is disqualified, because virtually every other president except Washington has taken an oath to support the Constitution, correct?
That's right. Every president, to our knowledge, every other president. John Adams might also be excluded because he took the oath as a vice president, which is not an officer. But yes, President Biden would certainly be covered. He took the oath as a member of Congress, and that's true of every previous president.
Would that be true if we were to hold...
They're talking about here that Trump never took an oath as some other officer of the United States, because he was the president.
And others as to whether Section 3 can be enforced by states against the president.
That would extend to every presidential candidate, not
exactly,
just our
not just to yours.
Yes.
Okay, thank you.
Justice Kagan?
And if I could just understand, I mean, given that you say you don't have a lot of evidence that the founding or the generation that we're looking at is really thinking about office versus officer of the United States, I mean, it would suggest that we should ask, is that a rule a sensible one? You know, if they had thought about it, what reason would they have given for that rule? And it does seem as though there's no particular reason, and you can think of lots of reasons for the contrary, to say that the only people who have engaged in insurrection who are not disqualified from office are presidents who have not held high office before. Why would that rule exist?
I don't think there is a good rationale, given that this was compromise
don't say
legislation.
that.
And sometimes this happens
on.
with statutory compromises and even constitutional compromises. There's an agreed-upon set of words that can pass both houses of Congress. But different legislators may have had goals and motivations. They didn't all get their way. In a compromise, everyone goes away miserable. But this was the text that was settled upon. And it does seem odd that President Trump would fall through the cracks, in a sense.
No, it's not, because you can't tell people they can't vote for the one person they get to vote for in the executive branch. One, you vote for president, everything else goes to Congress.
If you go to the office argument that Justice Jackson was suggesting, is there any better reason for saying that an insurrectionist cannot hold the whole panoply of offices in the United States, but we're perfectly fine with that insurrectionist being president?
I think that's
correct, because that person is elected directly by the people. Everyone else is not. So we're saying we're not going to let them do that. But if the people want to override us, they can. It's very simple.
So, again, that's why we're leaning more on the officer of argument than the office under. We're not conceding office under, but we definitely have the stronger textual case and structural case on officer of the United States.
Thank you.
Thanks.
Justice Gorsuch?
God,
respond to some of the specific textual arguments on the officer of with respect to the appointments clause, the impeachment clause, and some of the others.
Yeah, so the way, I'll start with the commission's
The ball
clause.
has been bouncing on that back and forth, and I wanted to see where you landed today.
There are three different textual inferences that could be drawn from each of those provisions Your Honor just mentioned. But the commission's clause, I think, is the strongest because it says the president shall, commission all the officers of the United States.
Correct.
Shall is mandatory. All is all-encompassing. And the president doesn't commission himself, and he can't commission himself. So that's one of the first problems. I think the Anderson litigants are trying to say, there's somehow an implied exception there because the president obviously can't commission himself, so we should construe that to mean all officers of the United States besides the president. But you also have members of Congress who are not commissioned by the president, and that's because they're not officers of the United States. So the only sensible distinction that we can see, given the language of the commission's clause, is that
what's going on here? I keep going. They're trying to say the president is not an officer of the United States, and he's not. But the reason they have to engage in that argument is because they list the first three. You can't be a senator right here. You can't be a representative. You can't be an elector, right? Or hold any office in the United States. That means you can't be the Secretary of State. You can't work, you can't be the Undersecretary of State. You can't be the Treasury Secretary. You can't be any of these things, right? And what the left is telling you is, they mentioned senators and representatives and electors, but they left president out, and president is right here. You wouldn't need to do that. You just say you can't hold any office, civil or military, of the United States. They don't need to do it. And this whole argument of officers is created because the left has been lying about it. And I'm talking about powerful people on the left. Lawrence Tribe, Judge Ludwig, and others have been lying about that. And if you look at other parts of the Constitution, it clearly lays out what an officer of the United States is. Somebody appointed or otherwise coming up under by the president.
And the phrase officers of the United States, reinforcing the idea that officers...
And one of the other problems you have here, and you hear it with the leftist judges, they do not like and do not understand the fact that the president is different. Of course he is. You know why? He's the only person in the government elected directly by the people. Now, other people are elected by the people for lesser offices, but not for the executive branch. Only one. Thereafter, the executive appoints other people, sometimes with consent, sometimes without. But that's the way it works. And they're uncomfortable with that, but that's just the way it goes.
Chase opines that states do not have the authority, that only Congress has the authority to enforce that. That could be evidence, as you say, of the
right here. Congress shall have the power to enforce it by appropriate legislation, which they did, and they repealed it.
The point then is it's reinforced because Congress itself relies on that precedent in the Enforcement Act of 1870 and forms the backdrop against which Congress does legislate. And then as Justice Alito says, the historical practice for 155 years has been that that's the way it's gone. There haven't been state attempts to enforce disqualification under Section 3 against federal officers in the years since. So whether that's a Federalist 37 liquidation argument, it all reinforces what
shocking that we're this far in the weeds over something that obviously everybody can see is the Democrats trying to interfere with democracy. It's just
I think that's exactly right. And the last part you mentioned, Your Honor, is crucial to our argument, that Congress relied on Griffin's case. It provided the backdrop against which they legislated, which is why we should read these extant enforcement mechanisms, and right now the only one left is the federal insurrection statute, 2383, as exclusive of state court remedies. It's a form of implied preemption, almost C. Clamor's implicit preemption of other remedies, because Congress made these decisions in explicit reliance on Griffin's case.
And if we agree with you on Griffin's case and what you've elaborated on there, that's the end of the case, right?
It should be, yes, unless Congress decides to enact a statute, which we can't do.
A new statute in addition to 2383. And just to be clear, under 2383, you agree that someone could be prosecuted for insurrection by federal prosecutors, and if convicted, could be or
be interesting to see if he concedes this. He should.
From office.
Yes, but the only caveat that I would add is that our client is arguing that he has presidential immunity, so we would not concede that he can be prosecuted for what he did on January 6th under 2383.
Understood.
Okay.
I'm asking a question about the theory of 2383. Thank you.
Thank you.
Justice Barrett?
So Griffin's case was a collateral proceeding, so it's habeas relief.
Yes.
Could Griffin have, so even if Section 3 is not a basis for collateral relief in habeas, which was new at the time, could Griffin have raised at his trial or in direct appeal the argument that Judge Sheffy, you can't legitimately sit or constitutionally sit on my case because you're an insurrectionist and you're disqualified? Could he have won then?
No.
Why?
Not if Griffin's case is correct. So
see, this is one of the essential things that just came to me. Usually don't say this, but once you start down these paths of idiocy, eggheads like lawyers will sit here and debate all this idiocy and act like it's legitimate. Okay, Griffin's case was a guy who got convicted, and he claimed, "Hey, the guy that sat over my trial was an insurrectionist, and he's disqualified. Therefore, my whole trial should be thrown out." And Chief Justice, he wasn't the Chief Justice then, but he later become the Chief Justice. He said, "No, it's not self-actuating, and Congress hasn't passed a statute. Therefore, it didn't apply to this guy, and your conviction is right." Right? We're talking about all this, and the whole thing, if you read it, doesn't apply to the presidency. It doesn't apply to today's world because there was no insurrection. To this day, right now, as they're debating this in the Supreme Court, not one single solitary person, not Trump, not any of the January 6 hostages, has been charged with insurrection. It's complete nonsense.
Congress enacts a quo warranto provision that would allow a state, or I guess it doesn't really matter for this purpose, even a federal prosecutor, to bring such an action against him, to remove him from office in the quo warranto way. Wouldn't that be in some tension with impeachment? He would be extracted from office outside of the process of impeachment. Couldn't then President Trump simply say, well, the only way to get me out of office is the impeachment process and not this quo warranto action?
So I don't know how that would play out, because the quo warranto actions that were brought, that I'm aware of, under the 1870 Enforcement Act, were brought against state officials. And Your Honor's impeachment hypothetical would apply not only to the president, but any federal officer of the United States.
I know.
So I don't know how that played out in the courts and whether anyone ever tried to argue that impeachment was the exclusive remedy for.
Well, I don't think anybody did argue it. I guess what I'm asking is, you said it's Congress's exclusive province, and you also said that it has to apply, after one is holding office, is elected. And I'm asking whether then the implication of your argument is that Congress could not enact such a provision that applied against federal office holders that were covered by Section 3 as opposed to state ones.
I believe they could. And the impeachment clause says that the president, the vice president, and all civil officers of the United States shall be removed from office upon impeachment and conviction. But it doesn't say that's the only way you can remove them. I mean, Congress can defund a position, and effectively, it's not quite the same as formal removal. But the other relevant precedent is Stewart against Laird, when the Jeffersonians repealed the Midnight Judges Act and abolished all of these positions for federal judges. And some people thought that was unconstitutional because they thought the only way you could eliminate federal judges was through impeachment. But Chief Justice Marshall upheld that statute. So that, to me, is a relevant precedent showing that impeachment is not the only way to get rid of a federal official.
Let me just ask one question, and this is just a point of clarification. Does President Trump have any kind of due process right here? I mean, I'm wondering, this kind of goes not to the cause of action point or the preemption point, but more to the question of what procedures he might have been entitled to. You don't make the argument that he was entitled to any, nor did I see the argument that he had any kind of constitutionally protected right to ballot access, so that he was, and constitutionally entitled to an opportunity to be heard. Is that
he certainly has a First Amendment right to run for president.
We made that argument below. We did not make that in our briefs to this court for several reasons. I mean, Your Honor's, I think, suggesting, and this is correct, that the proceedings below, to put it charitably, were highly irregular.
Well, I wasn't suggesting that. I was just
I'm sorry.
asking.
The question seems to suggest that there might be due process issues, but we didn't develop that argument in this court for several reasons. Winning on due process doesn't really do as much for our client as the other arguments that we've made, because that would
Your
be
client, how about the country?
To this particular proceeding in the state of Colorado, and would leave the door open for Colorado to continue on remand to exclude him from the ballot.
Okay, thank you.
Justice Jackson?
To whether the
This argument's been going on for about 45 minutes. It's hard to believe.
I'm a little surprised at your response to Justice Kagan, because I thought that the history of the 14th Amendment actually provides the reason for why the presidency may not be included. And by that I mean, I didn't see any evidence that the presidency was top of mind for the framers when they were drafting Section 3, because they were actually dealing with a different issue. The pressing concern, at least as I see the historical record, was actually what was going on at lower levels of the government. The possible infiltration and embedding of insurrectionists into the state government apparatus, and the real risk that former Confederates might return to power in the South via state-level elections, either in local offices or as representatives of the states in Congress. And that's a very different lens. If your concern is trying to make sure that these people don't come back through the state apparatus and control the government in that direction, seems to me very different than the worry that an insurrectionist will seize control of the entire national government through the presidency. And so I just am surprised that you would, given the text of the provision and the historical context that seems to demonstrate that their concern or their focus was not about the presidency, I just don't understand why you're giving that argument up.
We might get Justice Jackson on it. She's making a good point.
Is there any evidence to suggest that the presidency was what they were focused on?
There is some evidence of that. There were people saying we don't want Jefferson Davis to be elected president, and there was also one of the drafts of Section 3.
That's correct.
Specifically mentioned the presidency.
It was in an earlier draft.
But it wasn't the final.
It wasn't the
enactment.
Yes, I'm sorry. It wasn't the final enactment, but it does show that there.
And one of the reasons it probably didn't make it in is that when it goes out to the people and they see that, they might have voted against the 14th Amendment. Say, hey, wait a minute, you're telling me I can't. It's one thing if I can't vote for a senator or a congressperson. You're telling me I can't even vote for the president of the United States? Right? That was an important thing. I'm glad Justice Jackson is bringing this up.
We wanted to focus more on the text of the Constitution because this was ultimately a compromise provision that was enacted in Section 3.
All right, let me ask you another question about the states, because you have forcefully made an argument about the states not being able to enforce Section 3. So if we agree with you on that, what happens next? I mean, I thought you also wanted us to end the litigation. So is there a possibility that this case continues in federal court if that's our conclusion?
I don't see how it could unless Congress were to enact a statute in response to this court's decision.
So your point is that we would have to say congressional enacting legislation is necessary for either state or federal enforcement.
That's correct.
All right. Final question. The Colorado Supreme Court concluded that the violent attempts of the petitioner's supporters in this case to halt the count on January 6th qualified as an insurrection.
Oh, this is good. Finally getting to this.
By Section 3, and I read your opening brief to accept that those events counted as an insurrection, but then your reply seemed to suggest that they were not. So What is your position as to that?
We
come
never
on.
accepted or conceded in our opening brief that this was an insurrection. What we said in our opening brief was President Trump did not engage in any act that can plausibly be characterized as insurrection.
All right, so why would this not be what is your argument that it's not? Your reply brief says that it wasn't because I think you say it did not involve an organized attempt to overthrow the government. So
that's one of many reasons, but for an insurrection, there needs to be an organized, concerted
Correct.
effort to overthrow the government of the United States through violence. And this
so
riot
the point
that
is that a chaotic effort to overthrow the government is not an insurrection?
No, we didn't concede that it's an effort to overthrow the government either, Justice Jackson. Right? None of these criteria were met. This was.
I can't believe.
It was not an insurrection.
Maybe we won't
The
get
events
Justice
were shameful,
Jackson.
criminal, violent, all
it's
of
an
those
insurrection.
things, but it did not qualify
Wow.
as insurrection, as that term is used in Section 3.
Thank you.
Because, thanks.
Thank you, counsel.
Thank you.
All right, now we're going to get the people who want him excluded. It's their time to argue, and that went on almost 50 minutes. That's wild.
Mr. Murray?
Mr. Chief Justice, and may it please the court. We are here because for the first time since the War of 1812, our nation's capital came under violent assault. For the first time in history, the attack was incited by a sitting president of the United States to disrupt the peaceful transfer of presidential power. By engaging in insurrection against the Constitution, President Trump disqualified himself from public office. As we heard earlier, President Trump's main argument is that this court should create a special exemption to Section 3 that would apply to him and to him alone. He says Section 3 disqualifies all oath-breaking insurrectionists except a former president who never before held other state or federal office. There is no possible rationale for such an exemption, and the court should reject the claim that the framers made an extraordinary mistake. Section 3 uses deliberately broad language to cover all positions of federal power requiring an oath to the Constitution. My friend relies on a claimed difference between an office under and an officer of the United States, but this case does not come down to mere prepositions. The two phrases are two sides of the same coin, referring to any federal office or to anyone who holds one. President Trump's other arguments for reversal ignore the constitutional role of the states in running presidential elections. Under Article 2 and the 10th Amendment, states have the power to ensure that their citizens' electoral votes are not wasted on a candidate who is constitutionally barred from holding office. States are allowed to safeguard their ballots.
That's why I think he
excluding
spent too much
those who are
time on
underage,
that. He's right. It's just a waste of time.
running for a
You
third
can get elected,
presidential
but you're not
term,
going to go anywhere. Now we're going to have
or, as
another
here,
election. Silly.
those who have engaged in insurrection against the Constitution in violation of their oath. I welcome the court's questions.
Do you have contemporaneous examples? And by contemporaneous, I mean
This Justice
shortly
Thomas
after the adoption of the 14th Amendment, where the states disqualified national candidates, not its own candidates, but national candidates?
The only example I can think of, Justice Thomas, is the example of Congressman Christie, who was elected in Georgia in, I believe, 1868, and the governor of Georgia refused or declined to certify the results of that election because Mr. Christie was disqualified. But I think it's not surprising that there are few examples because we didn't have ballots in the same way back then. Candidates were either write-in or they were party ballots, so the states didn't run the ballots in the same way, and there wouldn't have been a process for determining before an election whether a candidate was qualified.
Also, people didn't
Unlike
make
the processes
ridiculous
that we
arguments
have now that
back
states
then.
have created under their Article 1 and Article 2 powers to run elections.
But it would seem that particularly after Reconstruction,
right,
and
people
after the
thought it meant the
Compromise
Civil
of
War, not just
1877, and during the period of Redeemers, that you would have that kind of conflict. There were a plethora of Confederates still around. There were any number of people who would continue to either run for state offices or national offices. So it seemed that would suggest that there would at least be a few examples of national candidates being disqualified, if your reading is correct.
Correct.
There were certainly national candidates who were disqualified by Congress refusing to seat them.
I understand that, but that's not this
That's
case.
different. That's not saying
states
can't be on the ballot.
disqualify them. That's what we're talking about here. I understand Congress would not seat them.
Other than the example I gave, no. But again, Your Honor, that's not surprising because there wouldn't have been states certainly wouldn't have the authority to remove a sitting
So what's the
federal
purpose
officer.
of the, what was the purpose of the Section 3? The states were sending people. The concern was that the former Confederate states would continue being bad actors. And the effort was to prevent them from doing this. And you're saying that, well, this also authorized states to disqualify candidates. So what I'm asking you for, if you are right, what are the examples?
Well, Your Honor, the examples are states excluded many candidates for state office, individuals holding state offices. We have a number of published cases of states considering that.
I understand that. I understand the states controlling state
right. Much different issue here. You're talking about President of the United States.
What we're talking about here are national candidates. I understand. You look at Foner or Foote, Shelby Foote, or McPherson, they all talk about, of course, the conflict after the Civil War. And there were people who felt very strongly about retaliating against the South, the radical Republicans. But they did not think about authorizing the South to disqualify national candidates. And that's the argument you're making. And what I would like to know is, do you have any examples of this?
Many of those historians have filed briefs in our support in this case, making the point that the idea of the 14th Amendment was that both states and the federal government would ensure rights, and that if states failed to do so, the federal government certainly would also step in. But I think the reason why there aren't examples of states doing this is an idiosyncratic one of the fact that elections worked differently back then. States have a background power under Article 2 and the 10th Amendment to run presidential
I don't think
elections.
this argument
they
that if they were different back then was going to work. The reason they were different is they didn't understand the amendment to be what they say now.
Everyone had received amnesty and these issues had become moot. So I don't think the history tells us.
Sort of look at Justice Thomas's question sort of from the 30,000-foot level. I mean, the whole point of the 14th Amendment was to restrict state power, right? States shall not abridge privileges of immunity. They won't deprive people of property without due process. They won't deny equal protection. And on the other hand, it augmented federal power under Section 5. Congress has the power to enforce it.
This is what you're talking about here,
wouldn't
Section
that be
1.
the last place that you'd look for authorization for the states, including Confederate states, to enforce, implicitly authorized, to enforce the presidential election process? That seems to be a position that is at war with the whole thrust of the 14th Amendment and very ahistorical.
No, Your Honor. First, we would locate the state's authority to run presidential elections not in the 14th Amendment, but in Article 2. And that power is nearly plenary to determine.
Yeah, but you're relying on, you have no reliance on Section 3, is that what you're saying?
No, Your Honor. Certainly we have reliance on Section 3 insofar as Article 2 gives states this broad power to determine how their electors are selected, and that broad power implies the narrower power to enforce federal constitutional qualifications.
Well, but the
like
narrower power you're looking for is the power of disqualification, right? That is a very specific power in the 14th Amendment. And you're saying that was implicitly extended to the states under a clause that doesn't address that at all.
Correct.
We would say
Does
that
Congress shall have the power
Amendment
to enforce by appropriate
states
legislation provisions.
the broad and nearly plenary power to
And
determine
folks,
the manner of selecting
the
their
tension here is because the courts have said these things here, all persons born naturalized, that is self-executing, the courts have said. So they go, well, you didn't necessarily pass a law to make that the case, right? And they didn't. So that's the tension.
federal power and certainly to restrict state power in some ways. But states are bound to enforce and apply, for example, Section 1 of the 14th Amendment. And so it's hard to see why states wouldn't be similarly bound or at least authorized.
That's greater includes the lesser argument. The states have the power, the legislature has the power to choose electors, granted. But just because there's one authorized means in the Constitution to a particular end does not mean that there's any means to that end. And so I think you're taking that electors argument and bringing it into Section 3, where, as the Chief Justice says, there's just no, and Justice Thomas, there's no historical evidence to support the theory of Section 3, nor the overall, to explain the overall structure of the 14th Amendment.
We certainly have a long history in this country of states using their power to determine the manner of selecting presidential electors to enforce other qualifications in the Constitution. I don't take it there's a great debate about whether or not states are allowed to exclude underage or foreign-born candidates, or if President Bush or Obama wanted to run for a third term, that they could be excluded under that broad Article 2 power. I don't see why Section 3 should be treated any differently. Section 3 speaks in the same...
Well, when you look at Section 3,
age and citizenship are
jumps out.
very easy to
And the question is,
insurrections
are, what does that mean? How do you define it? Who decides? Who decides whether someone engaged in it? What processes, as Justice Barrett alluded to, what processes are appropriate for figuring out whether someone did engage in that? And that's all of what Chief Justice Chase focused on a year after the 14th Amendment to say, these are difficult questions, and you look right at Section 5 of the 14th Amendment, as the Chief Justice said, and that tells you Congress has the primary role here.
Here's Section 5.
I think what's different is
Congress has the
processes, the definition, who decides questions really jump out at you when you look at Section 3. Your response to that?
Well, certainly, Justice Kavanaugh, there has to be some process for determining those questions. And then the question becomes, does anything in the 14th Amendment say that only Congress can create that process? And Section 5 very clearly is not an exclusive provision. It says Congress shall have power.
But maybe put most boldly, I think that the question that you have to confront is why a single state should decide who gets to be president of the United States. In other words, this question of whether a former president is disqualified for insurrection to be president again is, just say it. It sounds awfully national to me. So whatever means there are to enforce it would suggest that they have to be federal, national means. Why does, if you weren't from Colorado and you were from Wisconsin or you were from Michigan, and it really, what the Michigan Secretary of State did is going to make the difference between, whether candidate A is elected or candidate B is elected. I mean, that seems quite extraordinary, doesn't it?
It is.
No, Your Honor, because ultimately it's this court that's going to decide that question of federal constitutional eligibility and settle the issue for the nation. And certainly it's not unusual that questions of national importance come up.
Well, I suppose this court would be saying something along the lines of that a state has the power to do it.
Right, that's all.
I guess I was asking you to go a little bit further and saying, why should that be the right rule? Why should a single state have the ability to make this determination, not only for their own citizens, but for the rest of the nation?
Because Article 2 gives them the power to appoint their own electors as they see fit.
That's the best report you're going to have. Hey, it's Colorado's business who they vote for the president, right?
Then it's creating a federal constitutional question that then this court decides, and other courts, other states, if this court affirms the decision below, determining that President Trump is ineligible to be president, other states would still have to determine what effect that would have.
That's the best
on
argument
their
you
own
have.
state's law
Hey,
and state
50
procedure.
states get to elect who they want.
If we affirmed and we said he was ineligible to be president, yes, maybe some states would say, well, we're going to keep him on the ballot anyway. But I mean, really, it's going to have, as Justice Kagan said, the effect of Colorado deciding. And it's true. I just want to push back a little bit on, well, it's a national thing because this court will decide it. You say that we have to review Colorado's factual record with clear error as the standard of review. So we would be stuck. The first mover state here, Colorado, we're stuck with that record. And, I don't want to get into whether the record, maybe the record is great, but what if the record wasn't? What if it wasn't a fulsome record? What if, the hearsay rules are, one-offs? Or what if this is just made by the Secretary of State without much process at all? How do we review those factual findings? Why should clear error review apply? And doesn't that just kind of buckle back into this point that Justice Kagan was making,
absolutely
that we made with Mr. Mitchell, too, that it just doesn't seem like a state call?
3 points, Your Honor. The first is that ordinarily, of course, this court reviews factual findings for
Okay,
clear error.
that's what she's saying. But it's a bad rule because Congress didn't set up a way for you to do this, and you did it in a bad way.
That require a uniform
We do have rules for normal.
This court can do more, something more like a Bose Corp style independent review of the factual record. And we would have no objection to that, given that the record here, really the facts that are disputed here are incredibly narrow. The essence of our case is President Trump's own statements that he made in public view for all to see.
But then that's saying that in this context, which is very high stakes, if we review the facts essentially de novo, you want us all to just watch the video of the ellipse and then make a decision without any deference to or guidance from lower court fact-finding? That's unusual.
Well, ultimately, President Trump himself urges this court to decide the merits of his eligibility on the factual record here at page 2 of his brief. He's never at any point in this proceeding suggested there was something else that needed to be in the factual record, any other witnesses that he wanted to call to present his case. And again, the essence of our case is his own statements, and in particular, his own videotaped statements on the ellipse.
Mr. Murray, just to circle back to, I'm sorry to interrupt, but I wanted to, before we left it, I wanted to circle back to where Justice Kagan was. Do you agree that the state's powers here over its ballot for a federal officer election have to come from some constitutional authority?
Members of this court have disagreed about that.
I'm asking you.
The majority of this court has said that those powers come from Article 2, but we think that the result is the same whether the court locates it in Article 2 or in a reserved power under the 10th Amendment.
But you accept that this court has held. You're not contesting this or asking us to revisit that decision in Thornton or term limits or whatever you want to call it, that it has to come from some federal constitutional authority.
No, we are not, Your Honor.
Okay. And here we're not talking about the qualifications clause, right? Nobody's talking about whether he's 35 years
age,
old or
born,
whatever, right? Not an issue, okay. We're talking about something under the 14th Amendment and Section 3, so that's where you have to find your authority, right?
We find our authority in Article 2, in states' plenary power to run their elections.
Federal election, but this is for a federal office. It has to come from the Constitution, and you're seeking to enforce Section 3.
We're suggesting that in their broad power to determine them, to select presidential electors in any manner they see fit, they can take account of Section 3 and apply Section 3.
Could they do it without Section 3? Could they disqualify somebody for, on whatever basis they wanted outside of the qualifications clause?
That would run into term limits,
I would think so, right?
Yeah.
So it has to come back to Section 3.
Correct.
And if that's true, how does that work, given that Section 3 speaks about holding office, not who may run for office? It was a point Mr. Mitchell was making earlier, and I just wanted to give you a chance to respond to it, because it seems to me that you're asking to enforce in an election context a provision of the Constitution that speaks to holding office. So it's different than the qualifications
I still don't like this
clause.
argument. I mean, it's a good argument, but it's just too technical.
And serve, yeah.
I don't know that it is different.
Okay.
Other qualifications for office similarly talk about eligibility for the office. There's nothing unconstitutional about a 30-year-old trying to get on the ballot.
Except for this disability can be removed, right, under Section 3. That's what's different about it. So thoughts on that?
The fact that there's an extraordinary provision for removing the disability does not negate the fact that the disability exists today, and it's existed since January 6, 2021, when President Trump engaged in insurrection against the Constitution.
Still can't believe they have not spent more time on the fact that Congress moved the disability
before he left office ultra vires? Is that where your theory leads?
Well, that would raise the separate question of whether one can collaterally attack the actions of a de facto officer. And that may be the one place in Griffin's case at the very end where we would agree, which is when Justice Chase said, I've talked to my Supreme Court colleagues and we unanimously agree that you can't collaterally attack all official actions of an officer who's in fact holding the position under Section.
But just circle back to where we started, right? That this is Section 3, your authority has to come from there, and it's about holding office, and it's a particular kind of disability that can be removed by Congress, and it's the only one like that, right? They can't remove age or citizenship. How should that inform our thoughts about a state's efforts to regulate the ballot for a federal office?
The colloquy that my friend had with Justice Alito earlier, I think, is illustrative here. The fact that Congress has an extraordinary removal power does not negate that the disability exists today and exists indefinitely into the future, much like the fact that that the president can pardon somebody for a criminal conviction doesn't make that conviction somehow contingent. And I would note that if President Trump were appointed to an office today, if he were appointed as a state judge, he could not hold that office, which shows that the disability exists now. And the fact that Congress has a power to remove the disability doesn't negate the present qualification, nor does it implicitly bestow on President Trump a constitutional right to run for offices that he cannot hold in violation of state law and state procedure under Article 2.
In fact, there was a congressional action to permit Confederate officers or people who supported the Confederacy to hold office before the 14th Amendment, correct? So there must have been a thought that there was a pre-existing disqualification.
That's absolutely right. There were a flood of amnesty requests even before Section 3 went into effect because everybody understood at the time that those people would be disqualified the moment that Section 3 was enacted forever unless they received amnesty.
Counsel, what do you do with
they weren't running for president,
would
were
seem
they?
to me to be plain consequences of your position? If Colorado's position is upheld, surely there will be disqualification proceedings on the other side, and some of those will succeed. Some of them will have different standards of proof. Some of them will have different rules about evidence. Maybe the Senate report won't be accepted in others because it's hearsay. Maybe it's beyond a reasonable doubt, whatever. In very quick order, I would expect, although my predictions have never been correct, I would expect that a goodly number of states will say, whoever the Democratic candidate is, you're off
It'll be
the
chaos,
ballot. And others,
which is what the Democrats want. They want local officials to be able to do whatever they want.
A handful of states
It'll just be chaos. It's just the fact that we're just now over an hour into this thing, getting to this, tells you that
certainly, Your Honor, the fact that there are potential frivolous applications of a constitutional provision isn't a reason.
Well, no, hold on.
No,
you might think they're frivolous, but the people who are bringing them may not think they're frivolous. Insurrection is a broad term, and if there's some debate about it, I suppose that will go into the decision, and then eventually what we would be deciding whether it was an insurrection when one president did something as opposed to when somebody else did something else. And what do? Do we wait until near the time of counting the ballots and sort of go through which states?
This whole thing should just be shut down.
Which states aren't?
Supreme Court should say, hey, Congress, you have the power under Section 5. Go pass a law. Pass a law, then we can figure this out.
Since Reconstruction. Insurrection against the Constitution is something extraordinary.
It seems to me you're avoiding the question, which is other states may have different views about what constitutes insurrection. And now you're saying, well, it's all right because somebody, presumably us, are going to decide, well, they said they thought that was an insurrection, but they were wrong. And maybe they thought it was right. And we'd have to develop rules for what constitutes an insurrection.
Yes, Your Honor, just like this court interprets other constitutional provisions, this court can make clear that an insurrection against the Constitution is something extraordinary. And in particular, it really requires a concerted group effort to resist through violence, not some ordinary application of state or federal law, but the functions mandated by the Constitution.
On your point that it's been dormant for 155 years, I think the other side would say the reason for that is Chief Justice Chase's opinion in 1869 in Griffin's case to start, which says that Congress has the authority here, not the states. That's followed up by the Enforcement Act of 1870, in which Congress acts upon that understanding. Which is followed, and there's no history contrary in that period, as Justice Thomas pointed out. There's no history contrary in all the years leading up to this of states.
So what Kavanaugh is saying is, hey, we're just going to say Section 5, they have to have legislation. They did. They repealed it. There's no law. Nobody's disqualified. They should go further, but they won't. Kavanaugh is just going to say there's no law.
Have acted under that settled understanding for 155 years, and Congress can change that. And Congress does have Section 2383, of course, the Insurrection Act, criminal
which nobody
statute,
to this day has been charged with. Not Trump, not nobody.
155 years in relevant respects for what you want here today, at least.
No, Justice Kavanaugh. The reason why it's been dormant is because by 1876, essentially all former Confederates had received amnesty. and we haven't seen anything like an insurrection since then. I'd like to address your point.
Well,
Can I go to that point?
After the
Justice Alito?
I don't know how much we can infer from the fact that we haven't seen anything like this before and therefore conclude that we're not going to see something in the future. From the time of the impeachment of President Johnson until the impeachment of President Clinton, more than 100 years later, there were no impeachments of presidents. And in fairly short order,
that's a good point.
over the last couple of decades, we've had 3. So I don't know how much you can infer from that.
Certainly, but if this court affirms, this court can write an opinion that emphasizes how extraordinary insurrection against the Constitution is and how rare that is, because it requires an assault not just on the application of law, but on constitutionally mandated functions themselves, like we saw on January 6th.
Somebody please explain
attempt
why.
To disrupt a function mandated by the 12th Amendment and essential to constitutional transfer.
Well, let me ask you a question about whether the power that you've described as plenary really is plenary. Suppose that the outcome of an election for president comes down to the vote of a single state, how the electors of the vote of a single state are going to vote. And
such as in
suppose
2000 in
that,
Florida.
Candidate A gets a majority of the votes in that state, but the legislature really doesn't like candidate A, thinks candidate A is an insurrectionist, so the legislature then passes a law ordering its electors to vote for the other candidate. Do you think the state has that power?
I think there may be principles that come into play in terms of after the people have voted that the state can't change the rules midstream.
He's handling this pretty well,
because I'm not aware of this court addressing it. And certainly, as
well, let's change it so that it's not after the election. It's
right
3 days before the election, based on the fact that the polls in that state look bad. Can they do it?
I think they probably could under this court's decision.
He has to say that, which shows the problem with it.
For much of American history, state legislatures picked
correct
their own electors and assigned their own.
And I don't have a problem
constitutionally. But of course, that would be much more extraordinary than what we have here, which is simple application
again, most people
of normal
would have a problem.
State ballot access principles to say that we're only going to put on the ballot an individual who is qualified to assume the office.
Could I ask you again the question that Justice Gorsuch asked, and to which you responded by citing the de facto officer doctrine? But suppose we look at that going forward rather than judging the validity of an act committed between the time when a president allegedly engages in an insurrection and the time when the president leaves office. During that interim period, would it be lawful for military commanders and other officers to disobey orders of the president in question?
I'm not sure that anything gives military officers the authority to adjudicate effectively the legality of the presidency.
Why not? Because you say he's disqualified
from
the moment it happens.
Yeah, that's the problem that you're creating.
Officer doctrine might be used to prohibit people from seeking judicial remedies for decisions that take place after the date he was disqualified. But if he's in fact disqualified from that moment, why would anybody have to obey a direction from him?
Well, ultimately, there still has to be some kind of procedure in place to adjudicate the disqualification. Certainly,
it's been a while since I've watched the Supreme Court or listened to those live. They are really getting into the weeds on this, and they don't need to. It's a much simpler case than that.
On what theory? Because the Section 3 speaks about disqualification from holding office. You say he is disqualified from holding office from the moment it happens.
Correct, but nevertheless...
So it operates, you say that there's no legislation necessary. I thought that was the whole theory of your case. And no procedure necessary. It happens automatically.
Well, certainly you need a procedure in order to have any remedy to enforce the disqualification, which is different.
That's a whole separate question. That's the de facto doctrine. It doesn't work here. Okay, put that aside. He's disqualified from the moment, self-executing, done.
Right.
And I would think that a person who would receive a direction from that person, president, former president in your view, would be free to act.
He's trying to point out that if it's
wishes
self-executing,
without regard to that individual.
then it just leads to
I don't
these
think so,
kind of
because I
silly
think, again,
situations.
the de facto officer doctrine would nevertheless come into play to say this is
No, de facto, that doesn't work, Mr. Murray, because de facto officer is to ratify the conduct that's done afterwards and insulate it from judicial review. Put that aside. I'm not going to say it again. Put it aside, okay? I think Justice Alito's asking a very different question, a more pointed one, and more difficult one for you, I understand, but I think it deserves an answer. On your theory, would anything compel a lower official to obey an order from, in your view, the former president?
I'm imagining a situation where, for example, a former president was, a president was elected and they were 25 and they were ineligible to hold office, but nevertheless they were put into that office.
We're talking about Section 3. Please don't change the hypothetical, okay? Please don't change the hypothetical. I know I like doing it too, but please don't do it, okay?
Well, the point I'm trying to make is
he's disqualified from the moment he committed an insurrection, whoever it is.
Right. This is just pointing out the idiocy of self-execution.
Boom. It happened. What would compel, and I'm not going to say it again, so just try and answer the question. If you don't have an answer, fair enough, we'll move on.
He can't
compel a lower
he doesn't have an answer.
official to obey an order from that individual?
Because ultimately we have statutes and rules requiring chains of command. The person is in the office, and even if they don't have the authority to hold the office,
he's ignoring the
only
hypothetical.
way to get someone out of the office of the presidency is impeachment. And so I think if you interpreted Section 3 in light of other provisions in the Constitution like impeachment, while they hold office, impeachment's the only way to validate that they don't have the ability to hold that office and should be removed.
Mr. Murray, can I just ask you about something Justice Kagan brought up earlier, which is the concern about uniformity and the lack thereof if states are permitted to enforce Section 3 in presidential elections. And I guess I didn't really understand your argument or your response to her about that.
Well, certainly, if Congress is concerned about uniformity, they can provide for legislation and they can preempt state legislation.
Yes, but you say that's
not a bad answer.
But it's not necessary. In the absence of federal enforcement legislation, these questions come up to this court in the same way that other federal questions come up to this court.
That's not helping him. Even with the leftists, they're not going to like that.
The state hasn't provided sufficient
because what he's saying is, oh, well, just let any state do it, and you just come up to the Supreme Court, and you can just have a different record. Even the leftists aren't going to want a bunch of cases coming up to the Supreme Court.
Record and
he's losing the leftists. And I'm not saying he ultimately will, but not going to help.
Resolve it so that we have a uniform ultimate ruling on it. I guess my question is why the framers would have designed a system that could result in interim disuniformity in this way, where we have elections pending and
it looks like Jackson is going to vote no on this, which is good.
You're eligible, you're not, on the basis of this kind of thing.
Well, what they were concerned most about was ensuring that insurrectionists and rebels don't hold office. And so once one understands the sort of imperative that they had to ensure that oath breakers wouldn't take office, it would be a little bit odd to say that states can't enforce it, that only the federal government can enforce it.
No, it wouldn't be odd at all.
That Congress can
Why would it
essentially
be odd?
rip the heart out of Section 3 by a simple majority just by failing to pass enforcement legislation. Federalism creates redundancy. And here, the fact that states have the ability to enforce it as well, absent federal preemption, provides an additional layer of
That's his best argument, that they haven't done it, self-executing.
I'll ask you about the history when I get a chance again. Thank you.
Yeah.
Thank you, Counsel.
She did not answer his question.
Justice Alito?
Suppose there's a country that proclaims again and again and again that the United States is its biggest enemy, and suppose that the President of the United States, for diplomatic reasons, think that it's in the best interests of the United States to provide funds or release funds so that they can be used by that country president. A state determined that that person has given aid and comfort to the enemy and therefore keep that person off the ballot?
No, Your Honor. This court has never interpreted the aid and comfort language, which also is present in the
It's a good
treason
question.
clause. But commentators have suggested, it's been rarely applied because treason prosecutions are so rare, but commentators have suggested that, first of all, that aid and comfort really only applies in the context of a declared war, or at least an adversarial relationship.
He's not going to get away with this. He's expanding all the other language.
And second, the intent standard would do a lot of work.
What's going on here, if you look at the Maine lady, she went far further than Colorado. She didn't even bother with trial. But if you interpret it the way they are interpreting it, given aid or comfort to the enemies thereof also disqualifies you. And that's what Alito's
Let me come back to the question of what we would do if different states had adjudicated the question of whether
you're going to have 50 different rules, or maybe more than that potentially.
A different record, different rulings on the admissibility of evidence, perhaps different standards of proof. Then what would we do?
Ultimately, this court would, first of all, if there were deficiencies in the record, the court could either refuse to hear the case or it could decide on the basis of deficiencies.
They're supposed to be policing it for you.
Would we have to decide what is the appropriate rule of evidence that should be applied in this case? Would we have to decide what is the appropriate standard of proof? Would we give any deference to these findings by state court judges, some of whom may be elected? Would we have to have our own trial?
No, Your Honor. This court takes the evidentiary record as it's given, and here we have an evidentiary record that all the parties agree is sufficient for a decision.
That's not true. There's no way Trump's lawyers agree with that record. And I know they do, because they object to a lot of things.
Independent review of the facts. But ultimately what we have here is an insurrection that was incited in plain sight.
You're really not answering my question.
Yeah.
It's not helpful if you don't do that. Suppose we have two different records.
Right.
Two different bodies of evidence. Two different rulings on questions of admissibility, two different standards of proof, two different sets of fact findings by two different judges, or maybe multiple judges in multiple states. Then what do we do?
Well, first, this court would set the legal standard, and then it would decide which view of the record was correct, I think, under
Oh my God. The Supreme Court is doing factual findings?
Which record?
If this court had two cases before it, and both of the records were sufficient insofar as both sides had the opportunity to present their case and the essential facts in the record that everyone agreed was sufficient for decision, then this court would have to look at the evidence presented and decide which holding was correct, and then decide that issue for the country.
And
certainly here, when there is a complete record, lower courts then will be applying that decision, and I think it's unlikely that any court would say, we're going to reach a different decision than the U.S. Supreme Court did, particularly if the court relies on the facts, the indisputable facts of what President Trump said on video and in his Twitter feed, which is really the essence of our case here.
Well, you had an expert. Let's just take that example. Had an expert testify about the meaning of what President Trump said.
Right.
But do you think it's possible that a different state court would apply Daubert differently?
Correct.
And say that this person should not be allowed.
Daubert's an evidentiary rule about what should go to the record.
You think that's beyond the realm of imagination?
Not at all, Your Honor. 2 points on that. Number one, President Trump didn't appeal the admission of that evidence in this case. But number two, the second point is that Professor Simi really, he didn't opine on the meaning of President Trump's words. He opined on the effect that those words had on violent extremists. And the essence of his testimony was built around videotaped statements of President Trump himself, encouraging, inciting, and praising political violence.
I'm not taking a position one way or the other about whether the expert's testimony should have been admitted or anything like that, or the meaning of President Trump's words. I'm just trying to get you to grapple with what some people have seen as the consequences of the argument that you're advancing, which is that there will be conflicts in decisions among the states.
There'll be chaos.
Different states will disqualify different candidates.
Correct. Complete chaos.
But I'm not getting a whole lot of help from you about.
Well, because there's nothing he can do, Justice.
This would not be an unmanageable situation.
It would.
If this court writes an opinion affirming on the basis of the indisputable facts of what President Trump said on January 6th and in the weeks leading up to it, and his virtual confession on Twitter after the fact, then it would be reversible error for any other state to conclude otherwise on that question of federal law. Or at the very least, this court could address that when those issues come up.
Hard to believe this far after January 6th, they're able to say that with a straight face.
There's two sides to the other side's position. The first is that it's not self-executing. I want to put that aside. Deal with if we were to hold that states don't have the right to enforce or create a cause of action in this situation. they want the flip to say that no, but even Congress can't do it because they need implementing legislation. Address that argument. Because assume we rule that states don't have it.
Right.
What would you have us say for the other side of the argument? One of my colleagues says you need, or not then Chief Justice, but Circuit Court Justice Chase said, which is that somehow you need implementing legislation, like the 1870 Act. You seem to say that's not true because they could decide not to seat seat a candidate, et cetera. So I don't know that legislation's necessary.
And certainly there are historical examples of members of Congress under Congress's Article 1 power to judge the qualifications of its members, of members of Congress.
We're not talking about members of Congress. We're talking about the president.
Under Section 3 who have won election. In the context of the presidency, I think it would create a number of really difficult issues if the court says there's no procedure for determining President Trump's eligibility until after the election. And then what happens when members of Congress on January 6th, when they count the electoral votes, say we're not going to count electoral votes cast for President Trump because he's disqualified under Section 3 under the Electoral Count Reform Act. A number of the amicus briefs, such as those of Professor Ginsburg, Hassan, and Foley, have made the point that that is kind of a disenfranchisement and constitutional crisis in the making, and is all the more reason to address those issues now in a judicial process on a full evidentiary record so that everybody can have certainty on those issues before they go to the polls.
He didn't answer the question.
Mr. Murray, you talked, you relied on the state's extensive powers under the Electors Clause. You talked about the states having a role in enacting, typical ballot access provisions. I guess, it strikes me that we've put some limits on that, and I'll just give you Anderson versus Celebrezzi as an example of that, where we said, in fact, states are limited in who they can take off a ballot. Right. That was a case about minor party candidates. But the reason was that one state's decision to take a candidate off the ballot affects everybody else's rights. And we talked about the pervasive national interest in the selection of candidates for national office. We talked about how an individual state's decision would have an impact beyond its own borders. So if that goes for minor political party candidates, why doesn't it go a fortiori for the situation in this case?
Well, certainly constitutional principles like Section 3 apply to everybody, but in Celebrezzi, the issue there was a First Amendment question. And certainly there's no doubt that states' exercise of their power under Article 2 is constrained by First Amendment principles. And in that case, the state law deadlines for when a minor party candidate got on the ballot just came too soon to be reactive to what major parties had done and therefore risk disenfranchising people who were disillusioned with who the major parties had picked. And it raised First Amendment problems. Here, there's no real First Amendment problem, and a state is just trying to enforce an existing qualification that's baked into our constitutional fabric.
Yeah, I guess, it did come up in the First Amendment, but there's a broader principle there, and it's a broader principle about who has power over certain things in our federal system. And, within our federal system, states have great power over many different areas, but that there's some broader principle about that there are certain national questions where states are not the repository of authority. And I took a lot, First Amendment, not First Amendment, a lot of Anderson's reasoning is really about that. Like, what's a state doing deciding who gets to, who other citizens get to vote for president?
Colorado is not deciding who other states get to vote for president. It's deciding how to assign its own electors under its Article 2
That's his
power.
best argument, but it looks like they're going to lose Kagan, too, because she's uncomfortable.
Obvious, yes?
No, Your Honor, because different states can have different procedures. Some states may allow insurrectionists to be on the ballot. They may say, we're not looking past the papers. We're not going to look into federal constitutional questions. It's the sort of, even in this election cycle, there are candidates who are on the ballot in some states, even though they're not natural-born citizens, and off the ballot in other states. And that's just a function of states' power to enforce to preserve their own electors and avoid disenfranchisement of their own citizens.
Thank you.
Justice Gorsuch?
I haven't had a chance to talk about the officer point, and I just want to give you an opportunity to do that. Mr. Mitchell makes the argument that, particularly in the commissions clause, for example, all officers are to be commissioned by the president. Seems to be all-encompassing, that language. And I'm curious your response to that. And along the way, if you would, I poked a little bit at the difference between office and officer in the earlier discussion, you may recall. But I think one point your friends on the other side would make is, well, that's just how the Constitution uses those terms. So, for example, we know that the President pro tem of the Senate and the Speaker of the House are officers of the United States because the Constitution says they are. But we also know that they don't hold an office under the United States because of the incompatibility clause that says they can't. So maybe the Constitution to us today, to a lay reader, might look a little odd in distinguishing between office and officer, not prepositions, nouns, but distinction. But maybe that's exactly how it works.
It's exactly how it works. Of course.
I'd start with the idea that the meaning of officer in the 1780s was the same meaning that it has today, which is a person who holds an office. And certainly in particular contexts like the commissions clause, it appears that that's referring, that is referring to a narrower class of officers, because we know that there are.
Except it says all.
Well, we know that there are classes of officers, like the president pro tem, who don't get their commissions from the president.
Well, that's because the Constitution elsewhere says that.
We know that the appointments clause refers to a class of officers who get their appointment from the Constitution itself, rather than from presidential appointment. People who get their commissions from the president himself are not commissioned by the president. And so if you read the appointments clause in line with the commissions clause, then the commissions clause is really talking about the president's power. If one needs a commission, it's the president who grants it. But I think it's important to bring us back to Section 3 in particular, because that was 80 years.
Before we get to that, just the distinction between office and officer, do you agree that the Constitution does make that distinction, particularly with respect to the Speaker and President pro tem?
The Constitution makes that distinction, but at least in Section 3, an officer of the United States is a person who swears an oath and holds an office. Now, the President pro tem and the Speaker of the House, they don't swear a constitutional oath in that capacity. They swear a constitutional oath if they are a senator or representative in Congress in that separate
It's interesting to remember the trial judge in the Colorado case found exactly what my article said, is that it doesn't apply to the office of the president.
But don't swear an oath under
They're trying to
Article 6.
pigeonhole into this language, hold any office, civil or military, in the United States. They're saying that's where the president is. It doesn't make any sense. Justice Jackson made the same point.
I think that's a fair point, and I think that may be an exception to the general rule, and one might consider them perhaps officers of the House and Senate because they are appointed by those bodies and preside over those bodies.
Well, the Constitution says they're officers of the United States. So there are some instances when you have an officer but not an office.
Those may be an exceptional circumstance, but I would.
Thank you.
You're welcome.
Justice Kavanaugh?
The concerns of some question have been the states having such power over a national office. Other questions about the different states having different standards of proof. And they seem underscored by this case, at least the dissenting opinion below. Justice Sommore said, I've been involved, quote, I've been involved in the justice system for 33 years now, and what took place here doesn't resemble anything I've seen in a courtroom, end quote. And then added, quote, what transpired in this litigation fell woefully short of what due process demands, end quote. Now, I don't know whether I agree or not. I'm not going to take a position on that. But the fact that someone's complaining not about the bottom line conclusion, but about the very processes that were used in the state would seem to, and that would be permitted, seems to underscore the.
Still hard to believe we're this far into this, and there's any contemplation that this is not just anything other than completely.
Again, not disagreeing about the conclusion, but about the very fairness of the process.
Yes, Your Honor, but that language was, with respect to Justice Sommore, just not correct. President Trump had a 5-day trial in this case. He had the opportunity to call any witnesses
you gave you a fair process. We gave you justice because we say so.
He had the opportunity to testify if he wanted to testify. And of course, the process was expedited because ballot access decisions.
What about the people of Colorado? Did they get a fair hearing?
In this whole case, from
not
the
about
trial
Trump
court
necessarily,
all the
not
way
just
up
about
to
Trump.
this court, President Trump has never identified a single process other than expert depositions that he wanted to have that he didn't get. He had the opportunity for fact witness depositions. He had the opportunity to call witnesses remotely. He didn't use all of his time at trial. There was ample process here, and this is how ballot access
I can't believe this has gone on this far. This is
are
crazy.
decided all the time.
Okay. Second question. Some of the rhetoric of your position, I don't think it is your position, but some of the rhetoric of your position seems to suggest unless the states can do this, no one can prevent insurrectionists from holding federal office. But obviously, Congress has enacted statutes, including one still in effect, Section 2383 of Title 18 prohibits insurrection. It's a federal criminal statute. And if you're convicted
no
of
one's
that,
been accused of it.
You are, it says, shall be disqualified from holding any office. And so there is a federal statute on the books, but President Trump has not been charged with that. So what are we to make of that?
Two things, Your Honor. Section 2383 was initially enacted about 6 years before Section 3. It wasn't meant as implementing legislation related to Section 3. And I would emphasize that by the time that Section 3 was ratified, most Confederates had already received criminal pardons.
I guess the question's a little bit different, which is if the concern you have, which I understand, is that insurrectionists should not be able to hold federal office, there is a tool to ensure that that does not happen, namely federal prosecution of insurrectionists.
No, that wouldn't work because they could still run for president.
Clear, you are automatically
Ellen can run for president.
Holding a federal office. That tool exists, you agree, and could be used, but has not, could be used against someone who committed insurrection. You agree with that?
That's absolutely right, Your Honor. But I would just make the point that the framers of Section 3 clearly understood that criminal prosecutions weren't sufficient because oftentimes insurrectionists go unpunished, as was the case in the Civil War, and that the least we can do is impose a civil disqualification penalty so that even if we don't have the stomach to throw someone in jail.
Well, they had the quo warranto provision that was in effect then from 1870 until 1948, but then obviously that dropped out and hasn't been seen as necessary since then. Last question, in trying to figure out what Section 3 means, and to the extent it's elusive language or vague language, what about the idea that we should think about democracy, think about the right of the people to elect candidates of their choice, of letting the people decide, because your position has the effect of disenfranchising voters to a significant degree. And should that be something, does that come in when we think about should we read Section 3 this way or read it that way? What about the background principle, if you agree, of democracy?
I'd like to make 3 points on that, Justice Kavanaugh. The first is that constitutional safeguards are for the purpose of safeguarding our democracy, not just for the next election cycle, but for generations to come. And second, Section 3 is designed to protect our democracy in that very way.
Further nonsense.
The framers of Section 3 knew from painful experience that those who had
the way you're
broken their oaths to the Constitution couldn't be trusted to hold power again because they could dismantle our constitutional democracy from within. And so they created a democratic safety valve. President Trump can go ask Congress to give him amnesty by a 2/3 vote. But unless he does that, our Constitution protects us from insurrectionists. And third, this case illustrates the danger of refusing to apply Section 3 as written, because the reason we're here is that President Trump tried to disenfranchise 80 million Americans who voted against him, and the Constitution doesn't require that he be given.
I'm surprised we haven't gotten more factually into the record of whether it was really an insurrection.
So the general rule is that absent rare circumstances, state courts and federal courts share authority. State courts have authority to enforce the Constitution, but there are certain limits to that, certain situations in which the Constitution itself preempts the state's ability to resolve constitutional questions. And Tarbell's case is one, and you said earlier that once a president is elected, you accepted that a state couldn't do anything about that. Like Colorado couldn't enact its own, say, quo warranto provision and then use it to get the Secretary of State or the president or anyone else out of office. And I assume that's because of this principle of structural preemption. Am I right?
Yes, Your Honor.
Okay. So I just want to clarify what that means for your argument. That means that your eggs are really in the basket of the electors clause, really in the Article 1 basket, because you're saying that even though all of the questions that people have been asking have suggested that there's a problem with giving a single state the authority to render a decision that would have an effect on a national election. But you're saying that those structural concerns, which might otherwise lead to the kind of result that you would accept after someone is in office, are overcome by the electors clause.
Absolutely. States run presidential elections. That's very clear from Article 2. Once states have selected the electors and the electors have voted, states have no more power over the candidate who has been then nominated for president. But until then, the states do have the power to adjudicate
Again,
issues.
in the weeds. I don't know why
Justice
we're dealing
Jackson?
with this stuff.
So when I asked you earlier about the uniformity concern,
Right.
And
I think they've lost
troubling
justice,
potential
which means they've lost.
disuniformity of having
They're
different
not going to get any
states
of the
enforce
Republicans.
Section 3 with respect to presidential elections, you seem to point to history in a certain way. You said, I think, that the framers actually envisioned states enforcing Section 3.
Yeah, sure they did.
At least in some circumstances where there were insurgents and Confederates. And I guess in my view of the history, I'm wondering really whether presidential elections were such a circumstance.
She's
The
come back to,
framers,
second time she's come back to this.
actually envisioned states enforcing Section 3 with respect to presidential elections as opposed to senatorial elections, representatives, the sort of more local concerns. So can you speak to the argument that really Section 3 was about preventing the South from rising again in the context of these sort of local elections as opposed to focusing on the presidency?
I think Jackson
2
gets
points
it.
on that,
Doesn't
Justice
apply to the
Jackson.
presidency.
First
It's
is
more
that,
about,
as I discussed
again,
earlier, there
Congress,
isn't the same
senators,
history of
electors,
states regulating ballot
and then,
access at this time.
local
So
office
ballot
holders.
access
That's what they were
rules
concerned
to
about.
restrict presidential candidates wouldn't have existed. They wouldn't have been raised.
She's also got concerns about the lack of uniformity, right? And we see here, Colorado had a trial, but I'm surprised no one's brought this up. The Maine lady, when she kicked Trump off the ballot, she just did it on her own. She didn't have trial, didn't have any record. And no one's pushed back at that. I'm really surprised.
The presidency of the United States.
But then why didn't they put the word president
Exactly.
on the very
Thank you,
enumerated
Justice
list
Jackson.
in
They're not
Section
going to
3?
get her, I don't
The
think.
thing that really is troubling to me
Correct.
is I totally understand your argument, but they were listing people
Right.
that were barred, and president is not there.
Here you
and
go.
So I guess that just makes me worry that maybe they
That's the
weren't
point.
focusing on the
Senator,
president and, for
representative,
example,
or elector of the
fact
vice president.
that
That means
electors
electoral
of vice
college.
president and president are there suggests that really what they thought was if we're worried about the charismatic person, we're going to bar insurrectionist electors, and therefore that person is never going to rise.
Right.
This came up in the debates in Congress over Section 3, where Reverdy Johnson said, why haven't you included President and Vice
it did
President
come up.
in the language?
It's true.
And Senator Morrill responds, we have. Look at the language, any office under the United States.
Yes, but doesn't that at least suggest ambiguity? And this sort of
Yeah.
ties into
They're not going to get Justice Jackson. That's good.
In other words, we
Because
had
it really
a
needs to be a
person
unanimous
right there
decision.
at the time saying what I'm saying. The language here doesn't seem to include president. Why is that? And so
Right.
if there's an ambiguity, why would we construe it to,
Correct.
as Justice Kavanaugh pointed out, against democracy?
Right.
Reverdy Johnson came back and agreed with that reading. Any office is clear. The Constitution says about
The other problem with this is, as we know, trained lawyers, it doesn't matter what they said in the debate. People say all kinds of things on the Congress floor. It don't mean anything. What matters is the people that ratified it. What did they understand it to mean? What's the common meaning? Common meaning is just what Justice Jackson says. It doesn't apply to the
Focused on local concerns in the South. With this conversation where the legislators actually discussed what looked like an ambiguity. You're saying there is no ambiguity in Section 3?
Let me take the point specifically about electors and senators, if I might, because I think that's important. Presidential electors were not covered because they don't hold an office. They vote. And this
No, I'm
court's
talking about the
decision-
barred office part of this.
Exactly. So the
Right.
barred office is, if you want to include everybody, first you have to specify presidential electors because they're not offices, so they wouldn't fall under any office. Second of all, senators and representatives don't hold office either. The Constitution tells us that under the incompatibility clause and refers to them as holding seats, not offices. And so you want to make sure that there's no doubt that senators and representatives are covered. Given that the Constitution suggests otherwise, you have to include them. The Constitution says the presidency holds an office, as do members of this court.
No,
so
it doesn't.
Other high offices, the president
does not
vice
say
president,
that anywhere.
members of this court.
All right,
Fact,
let me
opposite.
ask you, I appreciate that argument. If we think that the states can't enforce this provision for whatever reason in this context, in the presidential context, what happens next in this case? I mean, is it done?
It is done, of course.
If this court concludes that Colorado did not have the authority to exclude President Trump from the presidential ballot,
then he's on the ballot.
Procedural grounds, I think this case would be done.
Correct.
But I think it could come back with a vengeance, because ultimately members of Congress may have to make the determination after a presidential election if President Trump wins.
So it's interesting.
Whether or not he's disqualified from office.
First time I've
heard to count votes cast.
Heard that argument, but they're gonna. What's gonna happen is what they're saying is if he gets elected, then we're gonna challenge him once elected, saying he's ineligible.
We think that the court should do so.
That's what they're.
And
That's
there's
what
no
that. This is
federal
crazy.
litigation, you would say.
Need to make sure I tweet that
correct,
out later.
because there
That's
is
crazy.
no federal procedure for deciding these issues, short of a criminal prosecution.
Wow.
Thank you.
Thank you, counsel.
All right, folks. It looks like the Supreme Court is done. Surprised they took as long as they did. The upshot.
Ms. Stevenson?
Mr. Chief Justice.
Anderson. No, Stevenson. That's right. I'm sorry.
More?
Mr. Chief Justice, and may it please the court. Exercising its far-reaching powers under the Electors Clause, Colorado's legislature specifically directed Colorado's courts to resolve any.
All right. There's going to be more. It looks like they're going to let some of the amicus people speak. I'm gonna get out. There were multiple briefs. For those of you who practice, you have to petition the Supreme Court by certiorari. Very few things are appealed directly to the Supreme Court. This was not one of them. They took the petition, they hear it, and then you have the two principal briefs. So you have the person that's appealing it, in this case Trump's team, and then you have the state of Colorado, which is challenging it on the other side. We heard from Trump's lawyers, we heard from Colorado's lawyers. You also, if you want, you can ask the court, hey, court, may I file a so-called amicus brief? And that essentially means friend of the court. And the court, more often than not, will let you do it. Not always, but usually they will. In this particular case, I think there were 40 or 50 amicus briefs filed. So it looks like they're going to give some oral argument time to these people that filed amicus briefs, which is fine. We're going to pull out because, frankly, I don't think we're going to see a whole lot more of what's going on here. Here are my just basic wrapping it up thoughts about what I saw here. I'm a little bit disturbed and surprised that and again, but this is what happens with lawyers. When I try my cases, I almost always want to go before a jury and not a judge for this very reason. Because lawyers, most people go to law school to be trained to think like I do naturally, which is very logical, very analytical, right? The problem with that is you don't see the whole of things, and you can go down rabbit holes. Things that make logical sense don't make sense in real life. And so we saw a lot of this today where people are buying all these different, like it's all nonsense. What are you talking about? They passed this thing. They meant the Civil War. They didn't include the presidency, right? And then they never enacted any legislation. Why are we here? And then let's see what you say. Okay, you say, well, each state can do it. Well, then we're going to have 50 different states doing 50 different things. Not to mention, in Maine, you had a Secretary of State do it. Here, you had a court do it. But you could have, even within states, you could have the courts disagreeing with the Secretary of State. So it's just unworkable. And then there's the record. I was really surprised by that. I think based on what I heard in the argument, it looks like Sotomayor is going to affirm. I think obviously the constitutionalists on the court, which are Gorsuch, Alito, and Thomas, it's dead as fried chicken. So they're gonna vote to reverse. Roberts, Kavanaugh, Barrett, a little bit. I mean, I would think they would reverse because it's such an open and shut case. It looks like Justice Jackson also is going to be reversed. I'm seeing probably 7-2, maybe 8-1. It will depend, but I think Sotomayor, which is unfortunate, but she's going to apparently looks like she's going to let it go forward. And then the last thing I want to impress upon you that came upon this, I'll tweet this out later, is and I also want to go over a couple of articles. And if you're interested in this, you can find them on my Substack page. Let me pull it up. In fact, so is that they signaled today? First time I've heard this, and I've been following this January 6th, 14th Amendment stuff. From the beginning. There's a lot on my Substack page, greatamericanmail.substack.com. A lot on this issue on that page. A lot of articles if you scroll through them. They are going to say, even if he wins, Okay, even if they say, no, we're reversed, he's on the ballot. Once he gets elected, people are going to file more lawsuits to say, well, he's disqualified. Fascinating that they're going to do that. Fascinating. Anyway, so here are the articles. The latest one was written on September the 8th. If you go to the Substack page, greatamericanmail.substack.com, and you scroll through, you'll find it written there. It breaks down the arguments why the 14th Amendment doesn't apply. And then we've also got another one. January 6th was not an insurrection. It actually was a very complicated process. And we've got, I think we can find video on this here. So this is an article was written January 6th, 2023 that breaks that down. And there's a bunch of others there. But I got to go do some other things, such as practice law. I'm going to be in court at 2:00. So I'm going to sign off. Hopefully we'll have something. I may do another shorter version of this later. That's not live, that just sort of breaks down what we saw, but fascinating stuff. It looks like Trump will be on the ballot based on what I saw today, but frankly, as open and shut as it should be, it's apparently, unfortunately, going to be a little bit more complicated. It should not be. Fascinating too that Justice Jackson appears to be with reversal. That's a little bit of a surprise too. Anyway, I'm going to head out, and I hope to see you again next time.